So with this one, the course 3 mock exam A.
You know what, Mark? I'm actually going to ask if we can do, if you scroll down about halfway down, it's the question 1 on, it looks like a second sample exam, residential 2. I read, just before I got on Skype, I read through that entire first one.
Oh, this one is done? Okay.
Yeah, I read through that and I understood everything on it, including the case studies. The one I didn't get to read through was the next one. The first question is complete the following sentence.
Perfect.
Requirements. That's the one I'd like to go over now if we could.
Okay, so that's part of the case study from case study number 6 then, right? Which is on, starts with number 1? Or is it after 40?
It starts at number 1, yeah.
Okay, so we're doing after 40. Alrighty.
It's on page 11 of 28.
Page 11 of 28? So that's the other one then.
Yeah, in that same PDF, it's on page 11 of 28. Sample exam C3, Res 2.
C3, Res 2. Sample exams. Okay, so yeah, C3, Res 2. So you're talking about page 11, right? Okay, perfect.
Yeah.
So that's mock exam B on that one.
Okay.
That's B. That's why. That's why I can locate it. Okay. So starting from number 1, it says complete the following sentence according to the requirements of Real Estate and Business Brokers Act. A registrant must deliver a copy of an accepted agreement of purchase and sale to the party being represented or being provided with customer service. It gives you 4 options here. A, only if the client or customer makes a request in writing. Do you believe that one?
I'm just rereading the question over. Deliver a copy of acceptance.
Yeah, if you did an offer as an agent, would it depend why you would give up a copy, or would you want to give up a copy as immediately or quickly as possible?
I probably want to do it as quickly as possible.
Yeah, I would agree with that.
Yeah.
And so we'll just look at all the options.
So then, probably.
Screen is jamming up. Okay, there we go. Yeah, so it would be D because you want to do it early as possible, not within 5 days, not within 72 hours, immediately. Because once you sign a legal agreement, like you're buying a car or signing a contract, you want to walk home with that contract. You don't want an opportunity for someone to take the paperwork and change anything on it, or allow an opportunity for something else to happen on it. That's a big problem, big concern for someone in that situation. What does the statute of frauds require when it comes to real estate contract? The contract for the sale of the real estate must comply with Vendors and Purchasers Act. The parties to the contract must be at least 21 for it to be enforceable. Parties to the contract for sale of real estate situated in Ontario must use Ontario Real Estate Association form. The contract must be in writing and signed by all parties in order to be enforceable.
So I think D probably.
Yeah. It would be D.
That's pretty. A lot of these are like pretty obvious, but they are in the exam too.
It's a mixture on the exam. That's why even the ones that are obvious ones, just make sure you read the question.
I always read all of them. I do process them in elimination.
Yeah, usually what they want to do when it's a really straightforward question is they want to add a little bit of trick language and change one word and try to see if you can, fall over on that and miss it, and then.
And that's where I got my ass kicked. With the bigger question.
Exactly. So let's go down to number 3. What are the requirements of the Real Estate and Business Brokers Act 2002 with respect to providing copies of a listing agreement to the sellers of the property? A says 1 copy of the listing agreement must be given to the sellers within 24 hours of being signed. B says sellers must be given a copy of the listing agreement at the same as an offer is being signed. C, each seller must be given a copy of the listing agreement immediately upon signing it. D is a copy of the listing agreement must be given to the seller within 24 hours of a request to do so.
I'm thinking it's C or D, but I'm going to say C immediately upon signing.
It's we like it immediate.
Yeah. Okay.
So you think of yourself as drive-through. You want it right then and there. There's no 24 hours. There's no 2 hours. There's no nothing. You sign it. You want a copy right on the spot, a carbon immediately.
Okay.
If you do a listing agreement with 2 people, you need to give them both a copy.
Yeah, I know that, right? So you just bring what? You bring 2 listing agreements with you. If you don't have a photocopier, obviously at their house, and just get them to sign.
Sure, but if you're going to someone's house, I'm pretty sure they have a scanner or copier.
Yeah,
most likely, right? And the best thing you can do, of course, is take 2 carbon copies and give them one right there on the spot. That's the absolute best thing to do, always. So you want to do that. But always same thing. Everyone who in the listing, everyone who signs has to get a copy immediately.
Okay.
Same idea.
Yeah.
Number 4, can a listing agreement have a term of more than 6 months? A, yes, providing the seller's initials, multiple service agreement on the first page. B says no, local boards will accept the listings for a period more than 6 months. C says yes, providing the seller's initials on the listing agreement next to the expiry date. D says no, OREA 2002 limits the term of listing agreement to a maximum of 6 months.
Well, I know it's yes. I'm going to guess C. I'm not quite sure about that.
It is C.
Okay.
Right beside the expiry date, there is an initial box that says, would you like to initial for 6 months or more?
I guess that's common sense because they're agreeing to what's right next to their initials.
Yeah, and they've situated right beside the expiry date so that it has complete clarity for them too.
Right. Okay.
And also for you too. So there's no misconception here.
Yeah.
Number 5, according to the Real Estate and Business Brokers Act 2002, at what point in time must a registrant advise buyers of the potential of multiple representations? A is as soon as buyers have signed a BRA, prior to entering the BRA with most buyers, prior to representing the buyer's offer, or prior to preparing an offer of the property for the buyers.
Okay, so according to REBA 2002, at what time must a registrant advise buyers of potential multiple representation?
Yeah.
Okay, well, if you're listing the house and your sellers, is that the position you're in there? Or
Yeah.
is when you brought a buyer to a house, you're putting an offer in, so it's before you put the offer in, obviously you have to tell them that there's other offers. Is that what they mean?
They're saying here, at what point must a registrant advise buyers of potential for multiple representations? So you could be working with a buyer, and there could be another buyer who wants to buy the same property, maybe. Could be the case. So it's asking, at what point would the salesperson advise of the potential multiple representations? Or it could be a scenario, multiple representation could be, you could be representing 2 buyers for one house.
Yeah.
Or you could represent the seller and the buyer.
I meant to say B. It's before you even sign it with them. That's one of the things you have to disclose to them, right?
Yeah, but prior to entering into the BRA with those buyers, you want to let them know.
Okay.
Yeah, definitely. So it is B.
All right.
You're like right on all of these so far.
But going through Christmas and holidays, I was scared I was going to forget everything.
Yeah.
I didn't review at all until really yesterday.
Right. Yeah, of course. It can slip your mind. I'm recording this session too, so you can re-listen to it again, even without reading
My
it.
next exam is in Kingston, so I got a 2-hour drive to listen to all these, so that should be good.
Perfect. Okay. Now, number 6 is Adriana has signed a listing agreement with ABC. Marvin has signed a customer service agreement with the same brokerage and is not a client of the brokerage because he's a customer.
Yeah.
Mohan wants to make an offer on Adriana's property. What does ABC Realty Inc. need to do in order to comply with REBA 2002 with respect to disclosing the nature of these relationships? So you've got...
There's not one on there. Let me just read it here. So Adriana signed a listing agreement. So Adriana's selling her house.
So she's the seller. She's got the house for sale with ABC.
So Marvin has signed a customer service agreement.
Marvin is a walk-in customer.
And
Mohan shows up and says, I also want to make an offer on the property. We don't know if he's a BRA client, and we don't know if or a customer.
So he's with another brokerage potentially. We don't know who he is. Or did he come to ABC Realty?
Well, it doesn't say he's got another agent. It just says he wants to make an offer too. So we assume he wants to work with ABC directly also. Like he could have walked by, seen the sign for sale, and said, "I'd like to make an offer."
Okay, I got it. Okay.
Could be like that. So, like we want to just look at the question for whatever it gives us. If it doesn't give us anything, we can't like put it in there.
Right. Yeah.
So 6A says prior to showing the property and presenting an offer, ABC must obtain written permission from the seller that it can provide customer service to the buyers. Okay. B says prior to presenting any offer, ABC needs to obtain written informed consent for multiple representation for the buyer customer. C says prior to showing the property and presenting an offer, ABC must obtain written permission from the buyer that it can provide client services to the seller. D says prior to presenting an offer, ABC needs to inform both buyer and seller, okay, in writing of the relationship in each of them that they're in.
I'm going to say A or D. I just have to reread A prior to showing the property and presenting an offer.
Well, A says you must obtain written permission from the seller that it can provide customer service. Do you need to do that? Do you need to go to your seller and say, I'd like to give customer service? No, you don't need to do that.
So I'm going to say D?
Yep, you're going to move right down to D.
You just have to disclose it.
You just have to inform both of them in writing because you want to have proof. So if you're going to make an offer on January 1st and you met them on December 31st, it would be a good idea to inform them and get it in writing and have them sign that piece of paper, and you have a paper trail that confirms that you gave them the notification and information, right? So you've informed them, and each of them respectfully understand the relationship that they're in.
Right.
Perfect. That's exactly what you want. Full disclosure. 7 says both chattels and fixtures are often included in the sale of a property. What is the best description of chattels? A, items that are included in the property unless they are listed in the agreement of purchase and sale as excluded items. B says items in a property that are leased rather than owned. C says property that is permanently enriched to a building. And D says personal movable items that are not a part of the real property.
Is it A?
A says that items that are included in the property unless they are listed in the agreement.
Oh, unless they're listed.
So chattels are usually described.
Okay.
So this A sounds like some kind of strange assumption scenario. Like you're assuming you're going to get the table and chairs.
Is it C?
It says permanently enriched to a building. So when I say chattels and fixtures,
you mean it's connected to the building, right?
If I say chattels and fixtures to you, do you think I'm going to be describing the fixtures inside the chattels, or do you think chattels is something different?
I think chattels are different. I think
I wouldn't say fixtures and fixtures to you, right?
Oh, right. Yeah. Okay.
So chattels would have to be something that's the opposite.
Okay.
So it's probably not fixed. It's probably going to be movable.
Right.
So you're going to lean towards D because chattels could be, let's say there's you've got things like a portable dishwasher, a portable washer, like things like that, okay? And they're not fixated into the property, but maybe the seller has said to you, you know what, I'm not going to take that with me.
Okay.
That's a chattel because it's not actually drilled or screwed into the wall or into the counter or into the, into the floor. So it's a movable personal item. Right. So I need to label that and I need to put it under chattels and fixtures in the agreement of purchase and sale, which there's a line where I'll write down all the chattels that are included. I could leave you the snowblower. It's not a fixed item. I could leave you heavy things because I'm moving into a condo and I don't need those larger things that come with the home.
Right, yeah.
So that's when you think of chattels, think of snowblower, think of something movable.
If you took the roof off and tipped the house upside down, everything that falls out, that's not attached to the wall, is not a fixture. So it's chattels and all those are up for grabs.
Right, exactly. Most likely, if you have a fixture in the wall, like there is a chandelier, unless I say it's not included, but the better thing for me to do is make sure I write it in the inclusion still, even though it's a fixture. But we don't want any miscommunication, and you don't want any. You don't want to be in a situation that's compromising because it's your fiduciary duty to do that. It's your job to do that, to make sure that there's clarity. So if I'm selling you the car, I'm telling you that the stereo is included. I'm telling you the heated seats are included when you buy it.
Okay.
So I could say, yes, you're buying the car, but the amp in the trunk, I'm taking it out. I would put it into my excluded chattels and fixtures. So that you have clarity and the person who's buying it has clarity too. Your fiduciary duty is done as well. Right?
Yeah, okay. I got that.
Let me just move my screen a bit here. Okay, so that's our... Come on. I don't know why my screen is so slow today. Okay, so now with 8, which of the following statements is correct with respect to an agreement of sale, agreement of purchase and sale? An agreement for sale provides the buyer with more security and protection than a sale financed with a mortgage. B, the buyer has a contractual interest in the property that gives the buyer possession, but the seller redeems title of the to the property until the required payments are made. C says an agreement for sale is an agreement of purchase and sale in which the seller takes back a mortgage on the property. And D says an agreement for sale is an assignment of an agreement of purchase and sale.
Okay, so that one's a little confusing to me.
It is. So it says, which of the following statements is correct with respect to an agreement for sale?
So the buyer has a contractual interest in the property that gives the buyer possession to the seller's redeemed title property until required payments are made. I have no idea, so I'm going to say B.
You're going to say B?
Okay, so that's wrong. Well, which one is it?
Let me just check my notes of explanation so I can explain it to you properly.
Is agreement for sale different from the agreement of purchase and sale?
They're asking for more or less a definition. What's an agreement for sale type thing, right? What is the agreement you come to sell the property? You know, I am on the wrong. Sorry, my notes are just flipping here back and forth. Let me just get back here. I think I've got it. Okay. There we go. There we go. Finally. Okay, so what's correct with respect to an agreement for sale? Agreement of purchase and sale is the forms. It's going to be the paperwork, the contract.
Yeah.
So this one is saying what is the what's correct in agreement for sale. So the first one that says the sale is financed with a mortgage, that's not necessary. You can buy a house in cash.
Yeah.
Agreement of sale has nothing to do with that. A is completely wrong as a statement. Now for C, it says that the agreement of sale is agreement of purchase and sale, and seller takes back a mortgage. There is no such guarantee of that. That's gone. And D says it's an assignment. An assignment is an assignment. It doesn't have a separate definition, so D is out the window too.
Okay, so what B?
So B says it's a contractual interest in the property, right? So you have an agreement for sale. They want to buy a property, but the buyer that gives the buyer eventually will give him possession. But the seller is first going to redeem the title, where you're going to first pay the money, and then he's going to release the title, and then you're going to take possession. So they're kind of giving you a little bit of step-by-step what's going to happen, play-by-play. But they're doing it a little bit backwards so that you get a little confused to not really look at B as an option right away. But it is a correct option for that reason.
Yeah.
Well, the other ones we eliminated very easily because they're completely off.
Yeah, just process of elimination in that question.
Yeah, they're totally off. 9 says, which of the following information can be obtained by a buyer's lawyer performing a non-title search of a property? So which information can he obtain? So A is previous owners of a property. B is records of discharge mortgages. C is outstanding mortgages, and status of property taxes.
Outstanding mortgages. And so he's not doing a title search.
Non-title search of a property.
Sorry?
A non-title search.
Records of discharge mortgage. Another guess, I'm going to say status of property taxes.
So if he's doing a non-title search, he's looking for something. What's the main concern you would have as a lawyer before you look at a property for your client you're representing?
An outstanding mortgage, I think.
Yeah, I think so too. That's so same thing as a car. What's the number one thing you're concerned about is the lien.
Yeah.
Right?
Okay.
So your answer for a non-title search, because title is related to the owners, owners are going to remember one thing. If you do a sale of a property, your lawyer's taking care of the closing.
Yeah.
The lawyer is going to automatically call the city and verify the taxes that are paid or outstanding, and put it in your statement of adjustments.
Yeah.
But the number one thing you need to understand is how many mortgages are there, because that's the biggest factor of what you have to discharge and how much money needs to be paid out and the time to process those discharges.
Okay.
Because if you have to call the city to find out taxes, what do you have to do? Find out how much is owed and pay it out. Really nice and simple, right? But the mortgage is the major concern if it's a non-title search.
Okay.
Okay? So that will stick in your mind.
Yeah.
You won't forget that question now. Number 10 says, just 2 weeks after the offer was accepted, so this is 14 days later, the buyer and seller would like to change the completion date, the closing date.
Right.
That was originally placed on the property on Bayview Avenue. The offer was made on an OREA agreement of purchase and sale form. How should this change be accomplished? Okay?
Okay.
A, the completion date on the original copies of the agreement, purchase and sale, should be changed.
Okay.
B says the counteroffer form should be used. C says an amendment of the agreement of purchase and sale should be used. And D says a new agreement of purchase and sale should be used. What would you think here?
I don't think the 2 weeks really has anything to do with it, because I think it can be done at any time.
It can be done anytime before closing, upon mutual agreement.
I think an amendment would take care of that, because you want to amend the closing date.
So here, let me just open it up. Sorry, 1 second here. So it says, when we look at it again, it says just 2 weeks after the offer was accepted, the buyer and seller would like to change the completion date originally agreed to. The offer was made on an OREA agreement, purchase and sale form. How should the change be accomplished? I would say that the amendment would probably be the most popular option.
Because you can do a new agreement.
But even if you don't do a new agreement, even if it's accepted, after it's accepted, you're not supposed to do changes according to like the office practice. You wouldn't do that. In the exam, they actually give you the option A as an answer. Believe it or not.
Oh, so they give you A as one of the answers?
They give you A as one of the answers, but I think I would look at the amendment as the best answer.
get it correct.
Yeah, I'm going to review this question as well because I have this question in a couple of different forms. So we'll save number 10 as a quick review to come back to, but for now you would actually use answer A.
My wife is telling me an amendment for sure.
Yeah, I would say it's amendment for sure, but on one of the exams it's marked off as
you want to check to make sure the exam answer is
Well, I don't know. Like, I think that sometimes the exam, unfortunately, when they write a question out, they don't actually include all the circumstances that apply to that situation.
Okay.
That's my only concern there. But I would stick with answer C is the correct one. For methodology, answer C is correct.
Okay.
Amendment is already what I agree with, but for some reason on some of the test exams that I have been provided from students writing them, they've got A is correct.
How do you get those exams, by the way? Like, do they remember all the questions?
Well, I do a really extensive student feedback form with a lot of students that have been on one-on-one training. So
Okay.
we go over the question and we screen it out, and we go like just for example, like when you looked at those questions that you got wrong, we go back and like scrutinize the whole question.
Okay.
And then I also have the pass it list questions, all the 500 questions as well.
Oh, right.
So we always double check against those older ones that are recycled, but a lot of them are just, they change a few of the names.
Same details, I realize
same
that,
question.
But the actual...
Same question. Yeah, it's the exact same question still. That's right. Okay, so let's look at number 11. It says the following statements are with respect to life lease projects. Which of the following is correct? A, life lease projects allow seniors to purchase the right to occupy a unit for their lifetime. Life lease projects provide an alternative for seniors who want to live in a home or want to live in a condominium but are unwilling to pay the maintenance fees. And C, life lease projects are designed to give tenants security for tenure and a monthly rent that will not increase over their lifetime. And D is life lease projects give occupants a simple fee interest in their unit plus a leasehold interest in various amenities such as fitness facilities and gym equipment.
I couldn't even guess that one. I don't know anything about life lease.
Nothing about life lease?
No.
Okay. Life lease is a combination of a couple things. So we will look at some of the answers that have combinations in them of a few things, okay? Now, if you look at, remember what fee simple was?
Yeah.
Okay, fee simple is something that we remember, plus it gives you a leasehold interest into it for amenities. So think of it where, this is more for American-style homes.
Okay.
Right? When you go to the States, I don't know if you've seen these communities where you own the home, and yet you have a community center right smack dab in the center of this whole suburb.
Okay.
You ever seen that before?
Yeah, I know.
Okay, so picture that in your mind. Okay?
Okay.
So we're looking at, you own the home, it's free simple, you can barbecue in the back, paint in the front, park your cars the way you like, whatever.
Sure.
Now you come in the center where they have the mailboxes and they have a community center that has got a gym, a pool, and a tennis court, which you're allowed to use. That's what a life lease project will feel like. So you have all of the benefits of living in your own home. You're completely independent. You don't have any strange restrictions. You don't live in a condo that makes you feel restricted. You live in an actual home with grass. But yet, when you want to go book a hall, or you want to have a community event, or you want to go to bingo, it's right down the street within the same complex. Right?
Yeah, so would you say D?
Yeah, let's say D.
Okay.
Yeah. Number 12, what kind of legislation covers some of the operational matters in a care home which provides independent and assisted living for mature adults? So you have 4 choices. Which one would you think it would apply to?
D.
D? Probably just open up my page down here. Okay, so why would you pick D, for example?
Well, they're technically renters. I've never heard of the first one.
Okay, let's eliminate them so that we are looking at them the same way. Okay, so it's asking for
Oh, so
in-home
the operational matters in a care home.
in-home care. Yep. And independent assisted living for mature adults.
Okay.
So it's not the Tenant Protection Act because they don't have to be a tenant.
Yeah, okay.
It's not the Condominium Act.
Cooperative Corporations Act.
What are co-ops? Do you remember what co-ops are?
Oh, tip of my tongue.
Even the welfare housing can be a co-op, non-for-profit.
Okay.
And then you got co-ops in Toronto that were created in the 70s, where instead of you owning a unit, you technically own 25% of a corporation, which is equivalent to a unit.
Okay.
That's like a co-op.
Right.
Right? And that can be a co-op for profit or a co-op for equity, and one would be a co-op for non-profit.
Okay. So, C then.
Yep. 12C. Because in 12C, you're kind of owning your seats. You're owning a share into the place you're living, right? You're not actually owning the home. It's assisted care. If the operational side of it is operating like a co-op. So you're paying a significant fee per month, the $4,000 a month or whatever the cost is.
Right.
And that's just to hold it over.
Right, okay.
Right? You're not actually owning any property, but they're doing everything for you, type thing. So it's the operational side of it for a care or independent assisted living type thing. Probably co-op corporation type thing. That's what a retirement home is, more or less. So retirement home, you're not a tenant. It's not a condo, and it's not a residential tenancy either. It's a cooperative corporation.
Okay.
So instead of it being non-for-profit, it is for profit, but it's operating along the lines that you have a right to have the food, the facilities, the service, based on the payments.
Okay.
Based on the equity you put down as well, or they divide it into monthly costs.
All right.
Right?
Yeah. All right, I got that.
It's confusing because it's such a tricky one. It's not a common scenario you would look at. I don't know really why the book is giving a lot of emphasis on it as a question, but I think it's more or less because you'll come across the sale of a residential tenancy for the actual project as a commercial business. So you might actually sell it. You might sell the land or do a deal on it. So it's just good to understand how the people actually living into it, how they classify.
Okay.
Just so you know, right?
Yeah.
13, in an agreement of purchase and sale for a building lot, which of the following guidelines should be followed? Okay. A description of the building to be built on the lot should be included in the present use section of the agreement. And then B, a buyer should verify or make the offer conditional upon verifying which services are available to that property. C says if a severance is required, there is no need for a condition, but it is covered in the pre-printed clauses. D says the lot dimension should not be included as minor discrepancies in lot sizes are common. So you're going to build a lot. What are your first concerns?
There's a few in there that I disagree with. The buyer should make the offer conditional upon verifying which services are available to the property.
Probably a good idea.
So, which of the following guidelines should be followed? Like, I would follow more than one of them, so I guess I have to pick the best one.
Yeah, so if it's definitely not D. That's just right out the window, right?
Yeah.
It says that in an agreement of purchase and sale for building a lot. So you're going to be building on a lot. You're buying an empty piece of land.
Yeah.
Which is the following guidelines that you have to follow?
The description of the building is not the present use.
Yeah, the description of the building to be built should be included in the present use section of the agreement. Because you're purchasing a building to build on, building a lot.
So I don't think that's because that's not the present use. So why would you have to put a future use on
When you make an agreement of purchase and sale, you're making an offer on something, right?
Yeah.
So if you're making an offer on something, the present use, you're not going to buy it as a blank. You're not buying a lot.
Yeah.
You're buying a lot that you want to build on. So they're selling you a lot that you can build on.
Mm-hmm.
You're not interested in buying a piece of blank land. The question is not really describing the situation properly. Okay. But what it's saying is that in an agreement, a person sell for building a lot. So you've already decided it, and that's all you're going to do.
Okay.
So it's very directed towards it. It's just not describing it completely to make sense.
Are they missing a word there for building on a lot?
No, it's build. They're saying that in an agreement, purchase sale building a lot. Like you've already decided that you're building a home on there.
Okay.
So your target for writing this offer is only because you're going to build a home on it.
Okay.
And like pretty quickly, like that's your goal, that's your aim. You're not buying a piece of land and saying, hey, you know what? Maybe 2 years later I'll build a house. That's not the scenario here.
Okay.
This scenario is that you are right on target and you're focused, and that's all you're going to do.
All right. So what's the correct answer for that one?
It would be A.
Okay.
So it says a description of the building to be built on the lot should be included in the present section of use on the agreement.
So would B not be correct as well? Like you should make an offer conditional upon making sure you got water, hydro, that kind of thing there?
Yeah, it would be. But that's only if you don't know if you can build a house on it or not.
Oh, okay.
The question says, in an agreement, a person's sale for building a lot. That means that you've already come to the point of making an offer on a property where you're already allowed to do that.
All right.
Okay, I'm sorry. I'm sorry that the question will not give you clarity, but remember this: that it would have given you the explanation, the question that if it was a scenario hypothetically, this one is saying that you've already approached.
I've done my due diligence. I know.
Yes, you've already approached a property that is ready to build upon.
Okay.
So the buyer doesn't need to go on verifying anything at this point in this question. So it's just giving you a shortcut in the first sentence to tell you you don't have to do anything else right now.
Okay, it's a bit of a confusing question.
It is, but it's on purpose.
On the exam, I'll know what it is now.
Most people would answer B and get it wrong.
Yeah, including myself.
But that's what I mean, that you have to read the question really, really carefully when it's especially when it's worded just like that.
Okay.
That's when it'll throw you off the most. Okay? That's like where you lose like 2 marks for no reason. Just remember, sometimes they don't explain or describe the question like I or you would to another person. So just try to catch the first sentence when they open up. If they don't give you an if or a but or possibility, then they're saying that's what it is already.
Okay.
That's where you're going to catch that trick language. Okay. 14 says Anna wants to buy a cottage with a frontage on a small landlocked lake, and then construct a dock or a boathouse on the shoreline. Who would Anna need to contact to obtain the permit, basically? Who's she looking for? Which authority would she need to contact to speak to get a permit?
The C, Ministry of Natural Resources.
Yep. So you remember that one?
I think so, yeah. Well,
Yeah.
I just know that because I know of a friend that was in a similar situation.
Right. So let me just one second here.
Do you want to go right to the end of this page here? Question 17.
Just give me one moment here. I'm just trying to scroll back up to where I was.
Are you on a Mac or a PC right now?
I'm on a Mac, but I think I have just too much stuff running all at once. I've got to shut some stuff down. Right, so, I'm so sorry. The screen is just making me go nuts today. Okay. So the answer to number 14 is C. Yeah, that's right. just wanted to check one thing that was coming up here. Run 2. That's why. Okay, there we go. Now I understand why my pages are doing that. They're actually a little bit all over the place here. Okay, 18. Perfect. Okay, now I've got it in order. Okay, 13. All right. I think what was happening was I was looking at a mixture of notes that I had and corrections, so I was just a little confused looking at a few things in between. So now for the question that we just did for 13.
14 we just did.
Yeah, not 14, but the when we were at 13, I want you to correct that answer. That was corrected on another exam that we did.
Okay.
So 13's answer, that question is actually, it's changed on the exam now. So that question we did about building a lot.
Yeah.
So that's been changed on the, it's going to be a little bit different when it shows up on the exam. That question has been updated, so that correct answer will now will be B.
Okay.
So ignore.
That's naturally what I would say.
Ignore. Yeah, exactly. So stick to that natural answer because the question is going to appear a little bit different on the exam slightly. That answer is going to be B now because you're going to remove that option of A.
Okay.
So that was an older one when they were doing it before. So now you can skip that, like just erase that and remember that answer now. Okay.
Okay.
So then that's completely perfect type thing. 12D. And also going back to 12, the there's an update on that answer for co-op corporations. Remember, well, there's been a few changes from the last 2 years. So when we were looking at the in-home care, so you might be living in your own home and having a nursing assistant. Okay?
Yeah.
So if you have a nursing assistant while you live in your own home, so that is a different scenario of it won't if it's not a retirement home. So there's two different answers. If it's in a retirement home, it would be the first answer that we talked about.
Yeah, that makes sense.
Now for 12, if you have in-home care in your own house, it's going to fall under D, the Residential Tenancies Act. So if it's in your own personal home,
okay,
it's the Residential Tenancies Act. If it's outside, then it's a different scenario.
Okay.
Okay, so just remember that differentiation between that.
Yeah.
Okay.
All right, no problem.
I just wanted to double check on my updates so that I make sure that you are got all of the correct things for the new exam that's coming up. And I want to just check one more really quickly. Also for number 11 as well. Number 11, we did life lease projects, give occupants a fee simple interest. Now that's going to be in a scenario where we're talking about that type of property. If it's referring to a freehold property where that's not the case. So this is referring to, like, you know, those properties that have a golf course, or you know those that for adult living they're designed in a certain way.
Yeah.
Okay. So if it has those amenities, then that D will apply.
Okay.
If it's respect to a life lease project, it will basically allow them to occupy the property for their lifetime. So it would be answer A.
All right. That's my first answer.
Yeah, if it's not referring to that other scenario. So if it's not referring to a shared golf course, if it's not referring to that clubhouse amenity system, then that home, they have the lifetime occupancy on it.
Okay.
Okay. I think that was it. I think that was the only ones that I wanted to make sure that those are updated for you. And you wanted to go down to 17, you said?
Let's just do 15, 16, 17.
15, 16, 17, okay. Okay, which of the following is a correct statement with respect to a property designated as a heritage property? A is alternatives to a property.
17. Can we do 15, 16, and then 17?
Oh, 15, 16, 17?
Yeah, don't mind.
Okay, here's 15. What might be one of the indications of a suspicious transaction could possibly be taking place? A client is purchasing multiple properties in a short space of time without inspecting them. B, a buyer client with substantial assets not wanting to give a large deposit with their offer. C, a seller client insisting on overpricing their property and not seeming concerned whether it sells or not. And D, a buyer client that is insisting on putting numerous conditional clauses in their offer but not insisting on additional inspections prior to closing.
Well, that could be a few of them.
Yep.
Like, I can see like an investor wanting to buy up in a low market a bunch of properties without inspecting them.
Right.
So I wouldn't necessarily say that. B, a buyer with substantial assets, but maybe he's not liquid, so he can't put a large deposit. You know what? I'm gonna say D.
So D says a buyer client that is insisting on putting numerous conditional clauses in their offer but not insisting on additional inspections prior to closing. You don't need to put additional inspections.
If he does a bunch of conditional clauses, like a home inspection, maybe he's happy with what he sees and doesn't need to come back.
But there could be other conditions too. It's not limited to home inspection.
Yeah.
So I could put in a condition, I'm going to buy this property from you, Kyle, if my son gets into the school.
Okay, yeah, I guess so.
So I could put a number of conditions on you. That doesn't really mean it doesn't make it suspicious.
What would you say the right answer is and why?
Let's say you wanted to buy 10 condos at square one right now within 2 months.
Okay, yeah.
And you didn't really want to look at them.
Yeah.
That sound a little strange?
I guess so.
That's the most unrealistic scenario.
Yeah, I guess so. I would just see it like an investor, someone wanting to buy up a bunch of.
So how would you feel if I said, I want to be your investor, I want to buy 10 condos, I don't want to look at them, we'll close a deal next month?
Yeah, that's weird. They're all weird, but I guess that's the most weird.
That's the most extremely strange one, because without looking at it, you should be extremely concerned. If someone doesn't look at it, that should be the biggest red flag in the world. Okay? And especially wants to buy multiple, like a bunch of them, without looking at them, and then also doesn't want to inspect them.
So he's dumping drug money is what I would think if I saw that.
There's a lot of scenarios I can share with you that are strange.
Okay.
And they all turned out terrible.
Okay, yeah, I figured.
Yep.
I'd run from any of those, like I said.
Yeah. You basically want to do business with someone who has a real goal and they want to achieve it and you want to help them. You meet an investor who says, I got $500,000, I have 2 kids, I want them to go to university, they probably need $250,000 each, and I don't want it out of my pocket. So I've got 10-year window. That's a real investor.
Okay.
Okay. 16. Which of the following would be an environmental concern for a buyer when purchasing a residential property? Access to the property by way of a private road. Property has an oil-fired furnace, but no visible oil tank. See the property is being sold by a mortgagee under a power of sale, or the property zoned for both residential and commercial.
Probably B.
B would be your biggest concern?
Well, as an environmental concern.
Yeah, I'd say so.
The rest of them aren't really environmental.
Yeah, I would say so too.
Okay, so let's say B.
So 16 is definitely B. Which of the following is a correct statement with respect to a property designated as a heritage property? Alternatives to a property require the written approval of a municipal council.
Okay.
B, because of the value and inherent to the historical nature of the property, municipalities tend to FRI realty taxes. Insurance premiums are typically lower than other homes of the same size. The property is subject to the same rights and restrictions as any other property, except for the installation of historical plate.
This one was on the exam. I remember that one. I don't think it's D at all. Okay, I think it's A, but isn't I think it's the heritage. Is there such thing as a heritage council, or is that just the property requires written approval from the municipality? I'm gonna say A. But I'm guessing I'm wrong.
No, A is correct actually.
Oh, okay.
A is correct because it's the municipal council, it's the city that's gonna write you the approval.
I guess so. Okay.
So there's 2 properties that you'll see at any time, probably that were old heritage properties that they'll either have building over them, around them, or behind them. But they won't demolish that property.
Right.
And then they'll put a heritage sign up in the corner of the entry of that parking.
Okay.
So the municipality will keep it regulated, keep it permitted, and never allow you to bring it down.
Okay.
Okay.
Alrighty.
And let's go to 18 then.
Yeah, sure.
As a general rule, which of the following statements would be correct in respect to assigning a contract? A, independent contract agreement between brokerage and salesperson is assignable. A mortgagee can assign a mortgage, but a mortgager cannot because the liability cannot normally be assigned to anyone else. C, agreements of purchase and sale are not assignable. And D is all contracts are assignable without any restrictions or limitations. Definitely not D.
Yeah, no. Would it be C?
Would be. Let's have a look. What happened here? I have no idea what happened. I was just browsing and my page disappeared. There we go. Okay, so as a general rule of thumb for signing contracts, you thought it might be?
I think it might be C.
C? Agreements of purchase and sale are not assignable. Why not?
Oh, okay, yeah, no, forget that then.
You could assign it. What if you bought a house and you signed it to your brother? Because it was really for him anyways.
So then it's A or B?
Yep, it's A or B. Which one do you think it is?
An independent contractor agreement between broker and salesperson is assignable.
If you signed an agreement with Remax, between Kyle and Remax, who would you assign it to?
Remax.
No, but who would be interested in assigning your independent contractor agreement? Like, why wouldn't they just sign their own? What would be the benefit of assigning your independent contractor agreement between a brokerage and yourself?
So explain that again. What?
A says an independent contractor. That's when you go work as a self-employed realtor for a brokerage. Yeah. So the contract is between you and the brokerage. What would be the significant purpose of assigning that contract? What would that accomplish?
I guess.
Who would want it when they can just walk in and sign their own contract?
I don't know. This one's got me confused.
But I'm just trying to ask you as a question. Do you think A would make any sense? Would that be something? Would John Smith, the realtor at Remax, say, "Hey, do you want to take over my independent contractor agreement, which is the same one you can sign anyways?"
Yeah, he could just go in. So you would not need to sign that. Okay.
Yeah.
So then that leaves B.
Yeah.
Explain why that's correct.
It says a mortgagee can assign a mortgage, but a mortgagor can't because a liability can't normally be assigned to anyone else. So if you take a mortgage, you can't go around assigning it to me, but the bank who gave you the mortgage, they could give you permission or allow for it to be signed to someone else. You're still responsible for it, but they would allow you to assign it to someone else, being that it's approved.
Okay, I got that.
Because all the other ones don't make any sense.
Yeah, it's just tricky wordplay in the question, but I got
Yeah. So you just got to remember who the mortgagee and who the mortgagor is, and then that question will make sense.
Yeah, that's what I got them reversed in my head. That's why.
Yeah. Make sure you understand what they are.
Okay.
Because that's why that question will be asked in that way.